All rise. The Court of Appeals, Division 1, is now in session.
Please be seated. All right. Good morning and welcome everybody to the Arizona Court of Appeals for Division 1. I'm Judge Jacobs. To my right, your left is Judge Perkins. To my left, your right is Judge Weinswag. We are here to have oral argument, as you know, in the case Schapker versus Ketzler-Naughton. We do record and live stream these proceedings so they can be watched later and they can be watched outside the court right now. So please, for this record, state your name and the name of your client before you give argument, if you don't mind. You have a 20-minute maximum per side, although you're not required to use all of your time. This one has extensive briefing. You probably will end up using all your time in candor, not on our script. We do require you to keep track of your own time, and the clocks on the podium tell you how much you have left in reserve, so please mind that and attempt to reserve. If you say you want to reserve some as appellant, we'll do our best to help you with that. Please keep in mind that we have read the briefing, we've studied the record, we discussed the case in conference this morning, and with that, when appellant is ready, you may please proceed.
Thank you. Good morning. My name is Michael Wright from the law firm of Udall-Shumway. With me is Lincoln Wright, who is my partner and son, and we represent Josie Naughton, and her mother Elizabeth is here in the court with us. On behalf of Josie, this case tests the reach of the principle that questions of fact should be determined by a jury. And the first issue of fact concerns whether Dr. Schapker was aware of the potential Naughton claim when he sold his professional corporation and failed to disclose it, and his motives in connection with the sale. The professional corporation is Bethany Women's Healthcare PC. I'm going to refer to it as BWH just for the sake of making it easier. By way of history, BWH was owned by Dr. Schapker. He was the sole owner and the supervisor of its operations. He operated a business that was a birthing center, employing midwives.
Counsel, just to try to aid your aiding us, I'd like to fast forward you through some of the preliminaries because we are well acquainted with that.
Okay.
I'd like to talk to you about the assignment clause and really the anti-assignment clause, if I could, please.
All right.
Okay.
Assuming that for purposes of this subject, Dr. Naughton was aware, it is important in interpreting the assignment clause as well as all of the contract, what he had in mind and what his motives were.
Well, first, before we get to the mental state of Dr. Schapker, I'm looking right now at paragraph 15 in the sale agreement assignment. This agreement and the rights of the parties, capital P, hereto may not be assigned. Is that ambiguous, and does it require parallel evidence to construe it, first off?
It's not ambiguous in this sense. The parties to the contract were the seller, Dr. Schapker, and the buyers, Dr. Ramuno, Lee, and Jew.
Is it ambiguous in any sense? Your answer suggests maybe it is.
It is not ambiguous in that sense. It is evidence, we say, further evidence of the motivation of Dr. Schapker in putting that assignment or non-assignment clause in. In other words, if he knew that there was this potential claim that was coming down the road, potentially, and hid it from the buyers, that is a reason to put in an assignment clause or a non-assignment clause like this. But it did not include BWH as a party to the contract.
To the extent that this is just a form clause, which it actually appears almost verbatim, or I think verbatim in a Westlaw form, I'm not sure that, how does that help your state of mind? This wasn't a crafted clause in this agreement.
If you look at the contract in its totality, you'll see that the buyers insisted that they be told of any and all claims. And they were assured that they had been told of all claims. The question of fact for the jury is, did Dr. Schapker know, and was that non-assignment clause should he be stopped, so to speak, or should he be held responsible for not telling them about the potential claim merely by throwing into the contract a non-assignment clause?
Counsel, let me just ask you, go back to the assignment clause.
Sure.
And I hate to take you back to law school, but isn't that sentence written in passive voice? It doesn't say who the actor is. There's no subject. It's just this agreement and the rights of the parties hereto may not be assigned. That doesn't identify the subject, so it's passive voice, right?
Right. But if you have a seller who sells a business to a buyer, and the seller has misled them, has committed fraud in the inducement, in effect, and has not told them about another liability that he promised in the contract, he had told them everything. If he puts in there, well, you can't assign this contract, it's a non-assignment, should he be allowed to get away with it? Should he be allowed to trick them, so to speak, knowing that there was a potential claim coming, knowing that they didn't even know about the birthing business, knowing that he had received notice of it, but they had not, and he puts that in, it's not effective in preventing him.
Counsel, I think
Yes.
now we can appreciate that your primary argument here is about his motivations, but I think what we're trying to get at is kind of like setting that aside. Let's talk about interpreting the text of the assignment clause.
All right?
I think that's what Judge Weinstein was trying to get at.
I understand the text of the non-assignment clause.
And counsel, let me break it in half for you to try to get us focused on that. The assignment sentence reads again, this agreement and the rights of the parties, capital P hereto may not be assigned. Let's start on the second half. The rights of the parties, capital P hereto may not be assigned. Is BWH a party?
No,
Okay.
BWH was not a party.
So the language, the rights of the parties hereto may not be assigned, cannot apply to BWH, correct?
Exactly.
Okay, let's deal with the slightly harder part of the sentence. This agreement, ellipsis, hereto may not be assigned. Does BWH have any rights under this contract?
BWH is not a party.
Right.
BWH is the corporation which was sold, the stock was sold.
But it acquired rights to indemnification in certain circumstances as against an array of potential claims, right?
It would have whatever rights for indemnification exist for a non-party. If there was no written contract, they would have the right to seek indemnification.
Okay, but we're not talking about the negative image, the common law. We're talking about this sentence. And so in this sentence, it says, this agreement hereto may not be assigned. Does the assignment, as you understand it in this case, purport to assign the totality of the rights under the agreement, or does it instead assign merely one claim?
It does not assign anything, or it does not allow assignment by anyone other than, it does not allow, it allows only the parties to assign, not assign the contract. It does not refer to BWH.
Well, can BWH assign, okay, try again. There's a prohibition. I take Judge Weinzweig's point that it's phrased in the passive voice. It said this agreement may not be assigned. So let's start with the easier one. The parties individually can't assign the totality of their rights under the agreement to someone standing off stage, right?
Right.
A party can't do that, right?
Right.
Okay. But assuming for the sake of discussion that this clause could apply to BWH, is BWH in this assignment, the one with the Naughtons, is it purporting to assign the totality of rights in the agreement, sir?
Well, in the contract, BWH not being a party has no rights or duties under this contract. It is not a party.
Let me ask you, counsel, if I could just direct your attention to paragraph 12, indemnification by seller. I'll read verbatim. Seller will indemnify company and buyer and hold company. So isn't that phrased as a right? Seller will indemnify company. So company has a claim, they're going to waive this contract.
That's right. Yes. BWH has a claim against the seller for misrepresentation or fraudulent fraud in the inducement when BWH gets sued by the Naughtons after the fact. So BWH could then assign their claim, or its claim, as a corporation. And the buyer standing behind the corporation, of course, can assign because they have been defrauded, they've been cheated, and in effect, either one of them could assign the claim to the
Counsel,
Naughtons.
let me try a different way. In the assignment of the personal injury claim that is at issue in this case, did the Naughtons receive all of the rights BWH held under the agreement, or a lesser included subset, like just some of those rights?
All of the rights.
They received every right that BWH possessed under the sale agreement.
The Naughtons received an assignment from BWH and from the sellers of any and all claims.
Of any and all claims relating to Naughton, or any and all claims that exist in the world?
No, any and all claims related to any liabilities that existed, liabilities of the company, of BWH.
So your point is, you're saying the Naughtons actually acquired all of BWH's rights under the agreement, period?
Yes.
Not the right to be indemnified for the Naughton claim, but all rights?
Well, all right, the only rights that they would assert were against the seller.
This difference makes a big difference for you, so I'd like to get your best answer on this point. Are you saying that BWH got all of the rights, I'm sorry, are you saying the Naughtons got all of BWH's rights under this agreement, or were the claims assigned a subset of those rights? Which is it? Is it the entire agreement that was assigned, or is it a claim under the agreement?
BWH did not have, was not precluded from assigning any claims that it might have. BWH was not cheated because BWH did not have a brain, did not know one way or the other.
Right.
It was the buyers who were cheated.
Right, but I guess to make it plain, there are two prohibitions in Section 15. We already went over the rights of the parties hereto may not be assigned. There's also a different prohibition. This agreement may not be assigned, okay? So putting aside your issue about fraud, which we're not discussing, like Judge Perkins said, this agreement, ellipsis, may not be assigned. So are you saying that this agreement, all of it, was assigned to the Naughtons? Or are you saying a claim but not the total agreement was assigned?
The agreement was assigned to the Naughtons.
Okay.
The agreement was assigned. That is the...
So the Naughtons acquired the whole practice?
well, no.
Oh, so it wasn't all assigned?
No, what they acquired was the right to seek indemnification.
Right, so just that one part?
Right,
Okay.
right. The right to seek indemnification, the right to, that the sellers had for being defrauded,
Right.
and so forth. Okay? Let me go back to the issue then on whether there was a question of fact as to Dr. Schapker's knowledge by way of history.
Actually, counsel, if you have remarks on the theme of vouching in, that might be most helpful as a second alternative
All right.
subject.
Yeah.
Thank you, counsel.
Sure, vouching in is a very long-standing legal principle. Party can be vouched in if the person who is sued has a claim against that party for the subject matter of the suit. And so by giving Dr. Schapker notice, asking him to come in and defend the lawsuit and undertake responsibility for the claim, then he could be vouched in that sense. Now,
Counsel, could you give me, what would you say is your best legal authority that vouching into one lawsuit is effective for a separate lawsuit?
is effective for what?
A separate, later lawsuit? In other words, having vouched someone in successfully to a 2017 lawsuit, what is your best authority that that is then effective to also vouch that person into a later distinct lawsuit filed in 2019?
Well, the party is vouched in for the claim. It's the same claim. The claim is the damage, the injury that Josie suffered. The lawsuit is merely an action.
But do you have a legal authority that could help me to understand that? Is there something this court has said or another court has said that clarifies this distinction based on a claim versus a separate action?
It's merely the legal principle involved. A claim is the injury and the right to seek damages for the injury. If you file suit, you get a case number, and if that is dismissed without prejudice, and you refile the same claim in a different case number, it makes no difference. It's still the same claim. And so it doesn't matter that it was dismissed and refiled. So going back to the issue then of whether the jury would have had a right to decide whether Dr. Schapker defrauded the buyers.
Actually, let's talk about something relating to the concept of vouching in. Why was approval never sought from the probate court, given probate rule 53? There's a pretty plain command in it.
It was, well, the Superior Court has jurisdiction as a probate court. The Superior Court, Judge Crawford at the time, had the claim in front of her, the lawsuit in front of her. She put it on stay pending this action, but that would not require a, quote, probate judge to approve it if Judge Crawford, the
But Counsel, that was something you're looking at Civil Rule 16.2, but 16.3 would have been, at the time when she was a minor, the operative civil rule, which then points you to Rule 53 of the Probate Code, which explicitly requires approval by a Superior Court judge in a probate proceeding under Title 14.
It never got to that point because it was put on stay. We filed a motion for approval of good faith determination of the
But I'm not
settlement.
understanding why you filed that, I guess is my point. The Rule 16.2 that you were proceeding under didn't really apply, not for these purposes, for the purposes of getting approval in the case of a minor, for the minor, a settlement on behalf of the minor for the minor's claims.
Well, the mother of the minor was acting on her behalf. She has been appointed her representative. The matter never got far enough to have a probate approval of the settlement and entry of judgment. It's still pending.
Why was there no effort to vouch in the 2019 personal injury lawsuit? Why was it possible to do it in the 2017 suit? And they say, oh, but you didn't do it in the other suit. Well, why not just do it in the other suit? This is terribly confusing.
Well, it had been dismissed without prejudice, so we just refiled it in effect.
Right. And
Same
since
claim.
they think that distinction matters and that you didn't vouch in Schapker in the later suit, why not just do it? Why not just vouch him into the 2019 suit?
Well, we considered that it was effective enough because he had not appeared. It can still be done. We could vouch him in. We've given him several opportunities to come in and answer for the suit. He's just never accepted those opportunities, so we went ahead and had a mediation and arrived at a settlement of the claim, and that has not been reduced to judgment yet. If it's necessary to vouch him into that, we're happy to do that, but he has refused to do it.
But the 2017 suit can now never be reduced to a judgment, and that's the only suit he was vouched into, right?
Well, we could vouch him into either one.
Right, but that didn't happen before we got it, which is all we can think about, which is
Right.
what already happened. He's not been vouched into a suit in which a judgment is possible presently, correct?
Well, that is a matter that was foreclosed by the summary judgment ruling. We would have gone to trial with the jury, had the jury determine whether it was fraud in the inducement, whether there would be liability, and or Dr. Schapker being held responsible for the claim, and then it could have proceeded from there. Either proceeded to judgment in the 217 action, which was inadvertently dismissed because we were trying to get him to be vouched in. I only have a minute left, so I'm going to save my time.
Okay. We reserve 1 minute and 35 seconds. Thank you, counsel.
I will just mention, though, that
Back on the clock then?
there's a substantial amount of evidence that a jury could consider as to whether Dr. Schapker defrauded the buyers.
Okay, thank you, counsel. You have 1 minute and 26 seconds now. Thank you, bailiff. When you're ready, counsel.
I remember and then forget just how close you are when you're standing here, everybody. I'm George King. I represent Dr. Schapker and Pamela Schapker. She was briefly a party. With me at council table is Renee Corey, who also represents Dr. Schapker, as well as Bill Klain. And then we also have Robin Reisinger on behalf of her client as well. So,
Counsel, I was going to wait 30 seconds to ask a question, so can you take us to section 15 and can we start discussing the assignment clause?
Sure.
And it's got those two parts. I'll wait for you to get your thing in front of you.
Oh my gosh.
But it's the agreement,
Oh, here. Okay.
yeah, the agreement and the rights of the parties hereto may not be assigned.
Correct.
Yeah, that's kind of a point of interest we have up here today, so I don't know if you have in front of you, Mr. King, but...
I do.
Okay. Let's talk about the second half, which I think is, to me, an easier question to deal with.
Yes.
The rights of the parties, capital P hereto, may not be assigned. Now, we can agree that BWH is not a capital P party to this agreement,
That's
right? Okay. So at least the second half of that sentence doesn't seem to foreclose, to me, the assignment that occurred here. Do you agree or do you dispute that?
I dispute that because, number one, the interesting argument raised about you can't assign the entire agreement, but you could assign portions of it, was never raised in the trial court. So it's an interesting argument that I had frankly not thought about until 20 minutes ago. But so that was not raised. We had no opportunity to brief, evidence, all that stuff.
Was it in the opening brief?
I don't think that they ever mentioned assigning only part of it. Their argument has always been that that paragraph 15 doesn't apply to BWH. That's always been their argument from day one. They've never said, oh, okay, we can assign some claims. But I don't think that it's fair to read this as a prohibition of an assignment only of the entire thing, because then you could game the system by saying, oh, okay, well, we're going to assign this practice to yet somebody else, but we're going to withhold the rights in paragraph 11C3, and therefore it's valid.
But the plain language just says the agreement, which is in its entirety. Now, I guess let me ask you, do you have familiarity? You've probably seen this during your career many times, assignment clauses. Does it ever identify that a subset of the agreement and the agreement can't be assigned, or does it just use this agreement and that includes each sentence in the agreement?
The latter. I've always seen anti-assignment provisions as you cannot assign this agreement, or you can assign any number of other things. The only time I've seen it called out separately is if there is an intent to allow assignment of something else. Like you could say, you can assign the agreement, you can't assign the payment streams because we have a security interest, something like that. But I have never seen an agreement written in the very interesting way that Judge Jacobs suggests, which is, okay, you got the whole thing, you can't do the whole thing, but you could do parts of it. I've never seen it called out like that before, but I will now think about it in contract drafting.
Well, Counsel, just a couple of points back, because I know time goes by really fast, 16 and a half minutes, but we do have enough time to slow down and discuss this, and I would like to slow down and discuss both halves of 15. You and Judge Weinsweig have now discussed the second question I wanted to get to, which is the half of line 15, which is this agreement, ... may not be assigned. And that's, I think, the better piece for you, and I get that. I get moving to that. That makes a lot of sense. I want to talk about the half I asked about first. Okay. The rights of the parties, capital P hereto, may not be assigned. How was the assignment in this case an assignment, if you contend it was, of the rights of the parties, which were not allowed to be assigned? How would that have been the case? I get the disagreement thing. How would the rights of the parties have been assigned in the BWH Naughton assignment, if at all? How's that work?
Oh, I don't think they work. Because,
Okay.
Yeah, I agree with you. No, I'm not going to fight you on that.
Oh, okay, well, that was my first question. We're on to the easier question, which, we do when we stand at that podium, right? Okay, all right. So the agreement here, too, may not be assigned. Now, correct me on this, but my recollection of the record is that you guys moved for summary judgment on this question. You have about a half page of text, and it doesn't really quote any cases, and it just says this language self-evidently doesn't allow this to occur, And I think that Judge Fox sort of pasted it in, and there's no additional authority in your brief or there. So I didn't see a lot of authority on either side about this, so I was unclear as to what anybody was arguing.
Right. The argument was, there were two arguments, one legal and one factual, both in the same service of what we think is an unambiguous, not to support the concept. Nobody tried to introduce evidence of you can assign part of it but not all of it. What you had was an attempt to invoke some sort of, I think, confusing parole evidence that, well, Dr. Ramona wouldn't have signed this assignment if he thought it couldn't be assigned. And I think we all know from being lawyers that people sign lots of things that turn out to be unenforceable in part or in whole, and the fact that they sign them doesn't mean they think they're enforceable. And there's nothing from Dr. Ramona to say that. He had an affidavit in the file. So there was that argument of, well, he must have thought it was assignable because he signed it. And he had an affidavit, didn't mention assignment or interpreting paragraph 15 at all.
Is there any parallel on Dr. Schapker's side? There is some parallel, as you alluded to. I think you said it was confusing or something. Their side has parallel about the construction of this provision. Does Dr. Schapker offer any on summary judgment?
No, because we thought it was always clear, and we were responding to their argument. Their argument was, it doesn't apply to BWH. And we said, no, the agreement may not be assigned.
Well, you say you're responding to their argument, but I think you affirmatively moved the Superior Court to enter partial summary judgment for you on counts 1 and 4, citing the unambiguity of this agreement, right, of the Section 15.
Right, and
That's your
because it's
motion.
ambiguous, it would be inconsistent to say, it's not inconsistent, but unnecessary, because until you came up with, I never saw that ambiguity. It did not occur to me that there was any sort of, and I'm not saying there is, because I don't think there is, but any ambiguity in the agreement versus some subset of the agreement to assign. So therefore, I didn't think to, have some sort of parole evidence to counteract that agreement that I frankly never considered, although it is very interesting. But I ultimately think that we went on that based on the plain language.
Whether or not it was a form, based on who was the proponent of the form, who drafted the contract?
It was negotiated over the court, and there's an email that they cite for Dr. Schapker being in a hurry to solve the practice, which makes no difference at all. And, he said, I have to go see my sister. She's terminally ill or dying of cancer. That's why he was in a hurry. But also in the email said this thing's dragged on for months because it was negotiated back and forth. The only evidence they have that it was drafted by Dr. Schapker was Dr. Schapker's lawyer saying, do you approve the form of these agreements? I assume that that's supposed to imply the form meant, like, it's their form and nobody negotiated it, and that's not a fair read of that email. So it's my understanding, and I believe there's no evidence to contradict that email, so I've been working on this stupid thing for months, that it was a back and forth. And I think that actually the Naughtons pointed out that there were some language changes in terms of, like liabilities actually known to the seller. They said, no, that was a last-minute change, allegedly because Dr. Schapker was worried about a lawsuit. He was worried in December 2016 about a lawsuit from a 2004 birth. So they changed the language. That's evidence that the language was negotiated.
So that is the best evidence that it wasn't drafted by Dr. Schapker, but was instead a joint project, is the thing you just said?
I believe that's correct. I think that there's no admissible evidence that any particular person drafted it. The only evidence, as I've given you, is that it was jointly drafted. The evidence they have, I don't think says what they say it says.
Sure. I'm sorry, just the one final follow-up, sure. Get off this, but so where in the record am I to look for your best evidence that it was jointly drafted and not drafted by Dr. Schapker? What is that I'm supposed to look for then?
Two things. One is that the Naughtons reference to the last-minute change. I don't think it was last minute.
And where is that in the record?
I
please?
do not know.
Okay.
The other one is, it's going to be in an email the Naughtons cited, and I believe it's an appendix to their brief, about that they cite for the incorrect notion that Dr. Schapker was in a hurry to sell.
So their own evidence also supports your theory, was the point you made? Okay, sorry.
No, I just want to encapsulate Judge Jacobs' question. So is the rule, you're familiar with the rule of law that says you interpret a contract against the party that writes it. You're familiar with that?
Yes.
Okay, so what you would say is whoever writes it or proposes it is irrelevant if it was negotiated after that, it loses that presumption.
Yes.
And then I would ask you, do you have authority for that?
I do not have authority for that. What I have is that we don't get to me, it's plain. The agreement came, I don't know how else you'd write it. Now I have some ideas, but until today, I had no idea how you would write, this agreement cannot be assigned, or may not be assigned.
You could have put the word company in there with parties, that might have helped.
I'm sorry?
I said you could have put the word company in there with parties, that might have changed the meaning.
Oh, well, that's true, but as to that second part, but, pull out the second part, because I agree with you on that middle part. That would have been interesting. But the point is, it was, to us, plain and clear and parole evidence, including who drafted it. You never get there because you say, well, it should be interpreted the way they want it. Well, there's no evidence on their side that they ever thought that it meant what, Judge Jacobs' theory on the, you can't assign the big part. You can't assign the big part, but you can assign subparts of it. There's absolutely no evidence on that side. That is just an interesting interpretation for which they have absolutely no evidentiary support.
Well, the counsel, on the idea of this agreement may not be assigned, I kind of like Judge Weinsweig's question before to your opposing counsel, so I'll just ask you, did the Naughtons acquire all the rights that BWH held under this agreement, or a lesser included subset? They didn't get the whole practice, did they?
Well, I don't know. Well, they said that they got the whole thing. I've never thought about all the rights in here because really it's not, I guess you could go through line by line and say, well, they didn't get there are a whole lot of representations.
If there's some windfall profit to BWH coming from some collateral source, is that assigned to the Naughtons too? Do they get every possible right or benefit of BWH?
No, BWH, the assignment, I think, well, there were trailing payments to Dr. Schapker, I believe, but I don't think they went to BWH. But what you're saying is there something in here that you could say, well, the Naughtons didn't get that? They think they did.
I'm asking you whether they did. I'm not asking you whether you think they think they did. That's a different question.
I think that, well, I don't think they got anything. So, I guess that's the simple answer, is they got nothing. But the answer is, the assignment, well, you'd have to look at the language of the assignment, but I think that the intent of the assignment was to give them whatever they thought they needed to do whatever they wanted to on their vouching in scheme. I don't think there was a great deep thought from the Naughton side on what they were assigning. So my point is, it could very well have purported to do that. Would that make sense? Probably not. But I can't answer, were they assigned all of it or just parts of it, because you wouldn't have to look at the assignment, you'd have to look at the actual assignment itself.
Okay.
And so...
well, let me try it this way, counsel.
Sure.
So let's say there's two different things we could do with this agreement, ellipsis may not be assigned. One of the things we could do is what you suggested broadly before Judge Fox and what he adopted, which is basically reading this agreement, ellipsis may not be assigned to mean anything relating to or pertaining to this agreement may never be assigned. That's one thing we could do. We could also say they're not assigning the whole agreement. What would you say to me if I'm skeptical of your position and you want to get me to that they really are assigning the totality of the agreement? That would help me land for you. Can you help me with that?
I can, because the entire point of an anti-assignment clause is to prevent assignment. And so there's nothing in here, in that assignment provision, that says you can't assign X, but you can assign Y. And so the purpose of that provision is there are no assignment. It may even, I don't know if they disclaim headings, but it says assignment. And it says the agreement on the rights of the parties hereto may not be assigned. But then it tells you in the next phrase what is allowed. But this agreement will inure to the benefit and be binding on the parties hereto and their respective successors and legal representatives. So what it tells you is if someone succeeds to BWH, they get the agreement, and it applies to legal representatives, whoever those folks might be. But my point is, normal people who write these things would intend this language, to me is very plain, that the bundle of things in the agreement can't be assigned. Because otherwise, what you suggest is, it would have been so much easier to say this entire agreement cannot be assigned, and the rights of the parties there too, which I think would be real. I've never seen anything like that.
Well, I just have one question. So you agreed it could be clear if it said company may not assign.
Yes,
Right.
you could, well,
It
and the rights of...
could also be clear if it said parties cannot assign,
Absolutely, that would have been a whole lot clearer. That's the way they read it, and that's...
but it says neither.
Right, and it's neither, but to me, if you are starting from scratch and you're lawyers, I don't want this, I want to prevent assignment. This assignment the parties are to may not be assigned, period. I don't know that someone would think to come up with your division of things to be the entire assignment, and in terms, because the whole thing says you can't assign it. And I said, well, if you read it carefully, maybe you could assign some parts, but not others. I think you can't assign it.
Well, I guess, counsel, so your point is that, this agreement is expansive, and it therefore enfolds the set of all things that could possibly be assigned. The point is, it's just called assignment. The point is to stop you from doing that, right?
Right.
Okay, so if this agreement, ellipsis may not be assigned, means the universe, why the heck does it also contain the disjunctive and the rights of the parties? Because your answer entails that in the rights of the parties is already included. So why did they bother putting in this second disjunctive half if the first one is the universe?
Belt and suspenders.
Okay.
Yeah, I think most legal agreements have twice as many words as they need. So, but yeah. Okay, let's see, I have 3 minutes and 23 seconds. I was going the whole notion, well, real quickly, in terms of all this stuff about whether Dr. Schapker knew, and that should be a jury trial issue, if you look on page 12 of their opening brief, the issues remaining before the Superior Court and not raised on appeal are whether Schapker knew of the pending Naughton claim. Of course, there was no pending claim.
Counsel, we're probably more concerned about vouching in than Dr. Schapker. Just state of mind, just to try to help you use your 3 minutes productively. Sorry, counsel.
Wow. Let's see. The vouching in, they do seem to say Dr. Schapker is a bad guy and defrauded his buyers who are not parties, and therefore you should allow the vouching in. There's sort of a big picture thing like that, but the vouching in, I think Judge
Yeah,
Perkins...
if you could respond to that specific argument that it's claim-based, not...
Right. I was starting to say Judge Perkins raised that issue.
Good.
And it's lawsuit-based because all of the restatements that apply to this talk about judgments. You are vouched into a judgment, not a claim, a judgment. It's in the restatement of judgments. That's how we do things in court, is we have lawsuits and judgments. And Judge Jacob had exactly the right point. Why didn't you vouch them in? And there's some suggestion that, well, maybe they could. Well, it's too late. I mean, I think they cited a case that, like 20 months had gone by or something. It's been years and years. That horse is out of the barn, down the road, and staying with someone else. So that one's dead. So I think that's where I would go, is that the entire case law, and I have some case law as well in there that talks about vouching into the judgment, but that's the whole structure of the thing, because they want to go, after the assignment, which I don't think is valid, they want to go to get some sort of garnishment and use the judgment. Well, they didn't purport to, they disclaimed any attempt to vouch Dr. Schapker into the 2019 lawsuit. I just mentioned real briefly, there are no fraud claims in this case. The word fraud doesn't appear in the February 10th, 2020 counterclaim third-party complaint, just not there. And there's no, so that was an odd thing that was raised. And the only people standing for fraud would be the buyers, and the statute of limitations expired that many years ago because they got sued. If they thought that they should have been told about a records request in 2013, that they got served, I think I want to say April 2017. So fraud, even contract claims by the buyers are now time barred. Mr. Malm cited, in response to Judge Weinsweig's question, Cheresia versus General Motors. We cite that too. So interestingly, on that if you're not a party, you can still get fees.
Isn't that say, I mean, I don't think you want me to go into this, but doesn't that say that you don't have to be a contract or party for the breach of an implied warranty?
I believe that it said that if you're a contract, you have a contract claim, you don't have to be a party to the contract. And so do you have a contract claim?
Is it all contracts or an implied warranty after you've purchased?
I think it applies to all contracts, but here it's easy because the counsel said that, let me finish this sentence at least, that he acquired all the rights in the agreement. And if you acquire the rights, you can't say that, if you say, I am suing under this contract, you can't say, well, I'm not a party to the contract. They wanted to be, have rights under the contract. And so they said, well, that doesn't count. I can address tail insurance, but I have no time.
Nope. Thank you very much for your argument, counsel. If we need to, we'll add about 45 seconds back, so we'll see if you're still going at 1:26. We'll give you a little bit of overtime here, counsel.
Thank you.
Please proceed.
By the way, the case that we cited on the question of whether the probate court judge has to approve any settlement is Marvin Johnson case 184 Arizona 98. It held that the Superior Court has the same authority basically as the probate court.
Well, Superior Court is the probate court.
Yes. Let me refer you to paragraph 12, again, of the sale agreement. Seller will indemnify company and buyer against all liabilities for any professional malpractice action against the seller or company arising out of any patient care matters handled directly by the seller. Well, why was that phrase directly by the seller put in? Was it to throw them off in case they found out about the Naughton claim? That's why you have to, I think, Your Honors, look at this contract and the events surrounding the contract in totality. Dr. Schapker, question of fact for the jury, knew about the Naughton claim. He sequestered the file in a box titled Old Lawsuits. And when it came to drafting the contract, where it requires him to reassure the buyers that there are no other liabilities, no other claims, you would think he would think about that and it would come to mind. Did he hide it intentionally or not? That's for the jury. That's for a jury to determine. Another point, the email...
Last point, counsel. You're at time, but please make one further point.
The email is at page 249 of our appendix in our brief. The email where Dr. Schapker got irritated that they weren't closing the deal and insisted that it be done right away. Further evidence for a jury that he wanted to rid himself of responsibility for the suit.
Okay. Thank you very much, counsel. We thank you all for your arguments. We're going to take the matter under advisement. We'll be issuing a decision in due course. Thank you very much for your time.